In this video, we're going to discuss intellectual property issues related to hiring personnel when you're a startup or an entrepreneur. Generally speaking, bringing on people to your startup is a good thing. It means you've raised capital to pay those people, and it means you have demand for your product or service, and you need to increase the staffing at your company. But bringing on people is also the #1 way that you can contaminate your company with third-party trade secrets and potentially incur liability for improperly accessing the trade secrets or sensitive information of some other party, such as a competitor. So let's talk about some of the issues to consider when you bring someone on to join your team. The first is whether that person has a non-compete agreement with a prior employer. We talk about non-compete agreements in another video, but generally speaking, you need to see whether that person is prohibited from working for a competitor and whether you need to wait a certain period of time before bringing that person on to your team. Another issue is whether that person is subject to a non-solicitation clause. A non-solicitation agreement typically prohibits someone, once they leave a prior employer, from going back and recruiting people from that company or from talking to the customers or business partners of that prior employer. Some non-solicitation clauses may be unenforceable, but it's at least important to know what agreements your new person has agreed to with a prior employer and what you need to do to avoid that person, and perhaps your company, violating the provisions in that prior contract. Another issue is intellectual property clauses in a new employee's agreements with a prior employer. We also talk about this in another video, but some intellectual property agreements can extend beyond the life of an employment relationship between an employee and an employer. And you need to consider whether those IP clauses cover work that the employer will do after they've left a prior employer. Another thing that has to happen is you have to actually have a conversation with that new employee or independent contractor to make sure they are not bringing with them any materials or information from the prior employer. They also need to be aware that they cannot be disclosing any of the sensitive information from that prior employer to people that you work for. And you need to inform the existing employees at your company that they can't be trying to talk to a new employee to get them to disclose information that's in their head that may be sensitive to a prior employer. That just needs to be an off-limits topic. When you bring on a new employee or independent contractor, you need to have them sign an agreement with your company that binds them to keep the information you share with them confidential. Typically, this document is called a Proprietary Information Invention Assignment Agreement, or a PIA. A PIA has a confidentiality clause. It may have a non-compete, non-solicitation agreement, if that's something that, based upon your company culture, you want to bind your employees to. And it probably has your intellectual property assignment language assigning to your company anything that the employee or independent contractor creates during the course of their work for your company. The PIA also has promises that this new employee or independent contractor is making to you that they're not bringing with them sensitive information from a prior employer or information that they're prohibited from bringing with them or sharing to you, and that they're not breaching any obligation they owe to a prior employer, such as a non-compete or non-solicitation agreement. These promises are important, although keep in mind that what's most important is that the employee actually is not breaking any of these promises. You don't want to have to go back and accuse this employee of breaking a promise that they've made to you in this PIA, but you really want them to, in fact, not be bringing any trade secret information with them and contaminating your company with that information. On the flip side, when your employees leave, you need to remind them of the obligations that they have to you to keep your confidential information secret, any non-compete, non-solicitation clauses, because once they leave, it's easy for them to forget about these obligations. So that's usually a good time to educate them on not taking sensitive information with them out the door and what legal obligations they have to you, even as an ex-employee. That's a very general overview of some of the intellectual property considerations when you bring on people to your startup company.